Hi, Aaron and Ryan. I'm Leon, everyone. Good to meet you. I'm the publisher at Your Life Choices. And yeah, we're here to present the first of what we hope will be many webinars in the future with Aaron and Ryan. Today's webinar is about wills, specifically wills made simple. Now, 50% of Australians don't have a will. I'm one of them. I know I should have one. You probably know you should have one too, but the process of creating a will, to me, seems confronting, a bit challenging, and expensive. But from what I've learned recently, it doesn't have to be. Today we're joined by Willed co-founders Aaron Zelman and Ryan Solomons, and we've asked them to come in and share their extensive knowledge and experience with wills and estate planning to simplify the process of creating a will. Now, we get a lot of questions about wills every week, and we do our best to answer them. But today, we hope that a lot of those questions will be answered with our simple step-by-step presentation, or should I say, Aaron's simple presentation. And you'll also have the opportunity to ask questions along the way. The guys will do their best to answer them during the presentation, or after the presentation, I should say, in a Q&A session. Now, to ask a question, you've already become acquainted with the chat box, which is fantastic. Type your question in the chat box. We'll run through them and we'll answer as many as we can today. If we can't answer them today, we will get back to you. The guys are more than happy to get back to you at a later date, but we'll try our best to answer as many of them as we can today. Now, if you watch to the end, you'll also have a chance to win wills for you and your family. You've just got to watch and listen carefully, because the answer to Aaron's quiz question at the end will be given to you during the webinar. So be the first to answer, and you'll win wills for you and your family. And even if you don't win the competition, you'll still be a winner, because Willed are giving you 20% off the cost of an online will with a special code that you'll see at the end of the webinar. Now, after today, we hope you'll be empowered with the knowledge that you need to protect your legacy and create your own will. And I'll be the first online. So, Aaron, how do we make wills simple?
Thank you so much, Leon. It's my great pleasure to present to your members and readers and audience on this topic, and joined by my co-founder, Ryan, who will be more involved towards the end of the presentation. So let's get into it. I should mention you've actually been asking some wonderful questions already. So what we've done is we've collated those questions and we've divided them into different sections, which I'll run through. So I'm hoping that we'll actually pick up on the bulk of your questions just in the presentation, but then there's a few curly ones and some interesting ones that we can share along the way as well as a chance to ask further questions down the track. So the key areas we're going to run through are key concepts around wills and estate planning, psychological matters, so things that go on in our minds that prevent people. Leon, I might even pick on you in this presentation. You know, what have been some of the psychological barriers for you to actually go and get your will? How to get it done, some simple steps and some practical ways to actually just get the job done. We'll also consider probably the most interesting or populous question for people is really how to prevent challenges. There's a lot of mentions of stepchildren and the like that are coming up in people's minds. So we'll have some chats around how to prevent future challenges on your will. And then other considerations. There's a range of topics that wills bring about and things that we'd love you to consider and want you to consider in getting all this done again. A big question as well for people is to lawyer or not to lawyer. And we represent an online platform that's been built by lawyers but can be made by the individuals, made by you. But there are some pros and cons of various approaches to this, and we'll address those in this presentation. As we mentioned, there's a giveaway. In fact, you just have to be the first to provide a correct answer in the chat, and that will be an A, B, C, or D. Once I've asked the question, go for broke and answer, but you can only answer with one answer. And if you don't get it right, it'll just go to the next person. And what you'll win, there's going to be 2 of these, but you'll win a family pack. It doesn't have to be for family per se. It's really 4 wills for you and whoever you like, really, friends or family, which you'll be really pleased to get, I'm sure, if you can win one of those 2 packs. A few, an advice warning, really, just in terms of when I run through this presentation, and Ryan as well, you can't take this as actual legal advice. I also represent an advice firm called Affinia Financial Advisors. And I need to make a statement that this information is general in nature and it doesn't factor in your own specific circumstances. So don't take these as actual recommendations. And Wild is a technology platform. It's not a law firm. So this presentation doesn't include legal advice. Okay, let's get into some key concepts. Starting with the basic one, what is a will? It's simply a document that outlines your wishes for your estate, meaning your assets, in the event of your death. Everyone knows that, but it's worth just starting with the absolute fundamentals. It's also sometimes called a will and testament, but really it's a will. And the reason it's called a will is it expresses your will, your desires, your wants, and captures that in a legal document. When do people usually get their wills? Well, it could be on a deathbed or in some sort of extreme scenario. It can be people just wanting to plan ahead when there's a pandemic on. It could be people approaching an elderly age, for example. A new child or grandchild might be in the picture. Obviously, a family, and just people who are very organised as well often get things done in this manner. On separation and divorce, often prompts people to just get a will done, or at least to redo those. And finally, the big one historically, not so much now in Australia, obviously, but people would be driving to the airport and trying to get a will in place in some way, shape or form. And so that will be a popular thing in the future, I hope, again, in the not too distant future. But these are probably the main prompts for people just to go and get a will done. As Leon mentioned, though, it's only about half of us who have done a will. I have actually done a will years ago. Many people just haven't done that. And they could be even lawyers. I actually speak to a number of lawyers who it's on their to-do list, would you believe? So you're not alone. But even those people who do it, there are a lot of people who still need to redo it or update it, as I'll be running through. So I would say the stats are even higher than 1 in 2 Australians need to address these matters. So let's just run through what happens when you die without a will. And the word for that is intestate. It sort of reads like interstate, which is where I've wished to be for months now, living in Melbourne, Victoria. Not that I'm unhappy here, but gosh, it would be great to get on a plane and go somewhere. Anyway, one of these days we'll get to do that again. But anyway, so if you've died intestate, what does that actually mean? So here's a few concepts to get your head around. Firstly, you're very likely to just disappoint people who you love and care about. You also may, if you've got young children, you might find, or you won't find, but they may actually end up in the hands of people who you hadn't intended to be their guardians, and that would be quite tragic, of course. Your money could go to the wrong people, even if they're family members who have various health issues or addiction issues, for example, just go in the wrong proportion to the wrong people, unfortunately. And what's that going to create? It's going to create family feuds, basically, and fights within the family, which really no one wants. And the big hassle of it all for the people you leave behind is really just dealing with the courts. The courts would have to decide how your assets get split up. Historically, there was a real risk that your money will just go to the state, and the various laws in each state have changed so that essentially your money will go to your family relatives in certain proportions. That's how it would get distributed. Only in rare scenarios where there is no living relatives would it go to no one. But just splitting it according to a formula may not at all be what you like. And there's a lot of traps with this, which we'll elaborate on in a few moments. And what does it mean if it has to go through the courts in this manner? Essentially, it means more cost to your loved ones and more delays in actually them getting your assets and getting on with their lives. Big headaches, really. Not your headaches, and a lot of people say that they can all fight over it if I'm not here. But if you actually love your loved ones in this life, well, presumably you would like to look after them in the future, and that's probably why you're here. I'll just take a bit of water. Okay, so some of the roles to consider. These words are probably familiar to you, but let me just explain them. A will maker, that's going to be you. And the executor, that's a really key role that we'll elaborate on in a few moments. Then you have beneficiaries, which in simple terms, beneficiaries are the people who receive the benefit of your will. I will define executor, sorry. An executor is usually the person, it could be an organisation. Sorry about that. Forgot to do my warm-ups. So an executor is the person who will distribute your assets and basically execute the will, manage the practical things that need to happen to wind everything up, sell things off, make sure the right people get the assets in the right proportion. And the fourth column won't be, or the fourth category is not relevant to everyone, but if you are a parent of children under the age of 18, again, it's about appointing or nominating who should be their guardians, and the court will then decide who those people are, but based on your stated preferences, of course. So what are some of these psychological matters? There's various reasons people don't get their wills done. We've touched on a few already. Firstly, some people are just too lazy. Leon didn't say that was him, but really some people, it's just, there's always tomorrow, basically. And then the other reasons would be that people are just too busy, it's too confusing, and it's really quite confronting. Finally, it is costly. And you add all these up together, and that's probably the reason most Australians really just haven't done their will, even though they need to. Some of these we can deal with. Being too lazy is very hard to deal with. We've got a few tips later on, but it's just very difficult to deal with. But these other three are solved by modern technology, and we'll run through some of those solutions in a moment. Let's just tackle the issue of it being all too confronting, the psychological barriers, really. So people are generally just worried about getting it wrong, making mistakes, and probably just dealing with this terrible scenario that they're not here in this world. But I think as we all get older, we know death is reality, and there's no point skirting the issue indefinitely. In fact, it's better to deal with these things sooner rather than later. But really, this all leads to a lot of procrastination. So let's go for a few tips as to how to deal with these obstacles. We want to go from overwhelmed to confident and getting it all done. So the first step is just understanding, educating yourself, and literally congrats for being on this webinar, empowering yourself with some good knowledge, and we'll cover quite a lot. We won't cover absolutely everything, but at least you're taking some really good steps to being able to make the right decisions and get it done through education. Next, it's communication. So that can be with your spouse. It can also be with people who you might want to be an executor, people who you might want to be your guardian, even potentially the beneficiaries, and understanding what would work for them. It's a thorny one, I must admit, but more communication is generally going to be a much better thing and lead you to getting it done. Next, I would suggest finding a buddy, meaning finding someone who also needs to get their wills done. And the final point, setting a deadline, working together and saying, we both need to do this. Let's get it done by X date. And that could be the end of this month. Getting it done, working together, ticking it off. And if you're not in this state, maybe going and have a beer together. So that's what lies ahead, to getting over the procrastination in 4 steps. I don't have to tell you how you'll feel to get it all done. It's pretty self-explanatory, because for everyone, it's a big to-do, and it's going to really put your mind at rest that you've done it. It's not something you're going to think about day to day, but it will just make you feel like I finally dealt with this thing. It's been hanging over my head for a long time, and I know I'm going to look after my family as best as I can. We're up to question 1. Hopefully you're listening. Now, the celebrity aspect will be general knowledge. You probably won't have time to Google this, but the question is, which celebrity out of the next 4 did not die intestate? And the correct answer will get yourself 4 wills for you and your family. Here we go. A, Pablo Picasso. B, Prince. C, Amy Winehouse. And D, John Lennon. A, B, C, or D, just type the relevant letter. I presume someone's done that. Hopefully someone's done that. Anyway, keep going. They're the screens. I'm going to keep pushing forward, but that's whoever clicked the right answer first will be getting a prize. We'll liaise with you as well, just to make sure that you get those wills done and get them done for free. Okay, we'll keep going. I'll mention the answer when I get to the next question, just in case you don't know. Let's focus in on Pablo Picasso for just a moment, because as I was researching him, I thought he was quite a fascinating case, just briefly. Now, you'd think that Pablo Picasso would probably have a few Picassos lying around the house, and I'm sure he did. The cost for his wills to be settled in the courts back in the 1970s actually came to $30 million then. So there's a lot there was a lot at stake, surely. And there was a lot of wrangling in the courts, clearly, and it costs a lot of money. I don't think anyone's estate is going to look like that in this country. But again, this is one of the consequences of someone dying intestate. All he needed to do really was to write a valid will, and this could have been avoided in his case. But it would have been a very beautiful will, I should say, I presume, if it was drawn. But anyway, let's move on. So how to get it done. I'm going to give you some practical steps as to how to get it done. Let's go. So there's really 5 big decisions. I've touched on some of those, but here's a schematic of these 5 decisions. you first need to choose an executor or executors. Now, I say it in plural because it can be a number of people. And also, I don't mention this on the slide, but I'd like you to think about who would be a backup. Your executor may not be available or able to operate at the time of your death. So having a backup in place would be really helpful in that event. And that's something you can do on the online platform, which I'll mention in a moment. But think of that. Who would be the backup? Same for guardians. Think about it if you've got children in that age bracket. And also cast your mind over to your own adult children if you have them. If you're a grandparent, for example, do you have children who need to get wills in place? And that's where the family concept also comes into getting all of your wills done. And hopefully they've thought about who would be the guardians of their kids, your very grandkids potentially. Not saying that you need to put your hand up for the job, but just it should be thought through and discussed and avoid the wrangling between different parties who do or don't want those kids, for example. The next step is to decide who gets the pets. Now that might be a surprising one, but if you own pets, the law really views pets as property. So if your estate's just split, I don't know how you split a cat or a dog, but if your estate is split, or even if it's just all goes to one person, they may not be the right person. It might not be a family member, for example, who should get your beloved dog to look after and care for. If you have someone in mind, a will is the place to write it, and that will make that process that much more secure. So if you have pets, who will be the new pet parent? Next, it's assigning specific gifts. So I've put there a picture of a precious guitar, for example. It could just be anything that's valuable to you. It could be a wedding ring. It could be some sporting trophies. Whatever it is, it's who do you want to own specific gifts? It could also just be a dollar amount. Who would you like to give $10,000 to, or whatever it may be? But think about what are the gifts, the specific gifts you'd like to. And the reason you do that is once those things are removed, you've got the last step, which is what often people think of, is simply splitting the residual estate. So in other words, typically, this percent goes to this person, this percent goes to this person, etc. And that's often how we think about it. But the process is simply going back one step, is who gets what gifts, and then who gets the rest of the estate. And as I mentioned, charities can be included in either the gifts or the splitting of your estate as well, if you'd like to do that. They're the 5 steps. Once you've thought through those, think about which method you're going to use to get your wills done. And we'll touch on this in a further detail in a moment, but effectively you've got your basic will kit. Some of you might have used already. You often see those at post offices or news agencies. The method that we'll talk a lot about today is online wills, and it's a very growing area. And finally, of course, there's seeing a lawyer to get all that done as well. I should mention that in the UK, it's about 1 in every 10 wills at the moment is getting done through online platforms, as reported in techcrunch.com. Okay, now it doesn't matter how you get your will done, it's going to need to be signed and executed in the correct way, and that is with 2 witnesses. And if we were sitting in a class now, I'd like to ask you what makes a valid witness, but I'll just have to tell you. Essentially, they need to be an adult over 18 who are not beneficiaries to your will. They have no interest in the proceeds of your will. They need to witness you signing the will, and they need to co-sign with you in that manner. That's what's required. And that's really an essential ingredient to what makes a valid will. Failure to do that will not see the will be a formal will in the eyes of the court. It doesn't mean it's worthless. It could still be a will that eventually stacks up in some capacity, but it's not a formal will and it could therefore be rejected.
Hey, Aaron, can I just step in there for just one second?
Yes, please, John. Go ahead.
Yeah, so I'll just add to that. A valid will requires, as Aaron said, to be witnessed by 2 adults who aren't the beneficiaries, but they cannot be the executors either. So no executors, no guardians, no beneficiaries, and it must be signed in the presence of the 2 witnesses at the same time. So you can't have the will maker sign in front of one witness, and then that witness leaves the room. The other witness comes in. Has to be in front of 2 witnesses at the same time in each other's presence.
Thanks, Ryan. Fantastic. Okay, we'll move on to preventing challenges. So there's a few categories of challenges. Firstly, let's start off with these 3, which is incapacity, undue influence, and formalities. I'll go back. Incapacity is the charge that the person writing the will didn't have the capacity, didn't have the mental wherewithal to know what they were doing, basically. And that questions the validity of the will and can really see a challenge made. Similarly, if they were under undue influence, in other words, someone was standing, well, I don't know what the example is necessarily, but it was obvious that they were being pressured to get something done and write something in their will, that could lead to a challenge as well. And formalities, like we mentioned, not having the right witnesses in place, not signing it correctly, leaving off as part of the document, for example, can lead to the will being rendered invalid. And again, that could be challenged. But probably the main thing that people think of in terms of challenges is what we call family maintenance claims. And let's focus on that area now. Family maintenance claims essentially are a claim where a person is a family member typically, and they say, I was not considered appropriately in the will, this is unfair. And this is what a lot of people are worried about happening for various reasons. So to make such a claim, it needs to generally be a spouse, partner, parent, child, or stepchild, but it can include other relationships that looked other relationships that were dependent as well in that sort of family context. Okay, so the court will consider various factors, and I'll just list through these, and you can cast your mind to your own people in your life and to see whether this would be relevant or not. But the first question the court will consider is this was there a moral duty to look after that person? Next is, was there adequate provision in the will? So leaving a person out of the will entirely could actually be a negative. Having a provision, if it's considered adequate, could actually prevent a challenge. Next is if the claimant is capable of providing for themselves. That will influence the court's ultimate decision. Next, other considerations. So what can and what can't be included in a will? So we think of it as, well, our assets can all be picked up by the will, and there are a lot of asset classes that could be, or types of assets. It could be a home, of course, it could be jewelry, it could be cash, it could be shares that you own or a car, etc. Various other things, but your personal property will generally be picked up in your will. But what will not is super and trust assets that you might have, and property that's owned jointly, joint tenancy property. There's a concern there, or should I say, people will think an account, for example, that's owned in two names, well, you could just pass your share, but it's not viewed as shares. In joint tenancy property, when a person dies, then the entire asset goes to the other side of that equation, the other co-owner of that asset. And superannuation, again, is not something that your will automatically can control. The way to make sure your super goes to the people you intend is through nominations of beneficiaries, which you would do with your super fund. And failure to do that, again, could cause quite a lot of problems. So let's focus in now on executor matters. As I said, an executor is that person or an organisation that essentially executes your will. And some of the ideal qualities for such a person, which is one of the questions, we would say would be that that person should be trustworthy. They need to be competent. So both mentally competent, but also know how to deal with financial assets and an estate down. That requires a level of competency, obviously. You would ideally like them to be available and be local, and they will need to give quite a bit of time and effort in managing or winding up an estate. So they need to have the time. If they're extremely time poor, they really may not be suitable. Now, some people ask, can an executor be a beneficiary? And the answer is they can. There's no reason why they cannot. So keep that in mind. And as I've said before, including backup executors is something that we would highly encourage people to do. And again, failure to nominate a backup executor could cause all sorts of problems down the track. Again, updating your will to change executors may well be required. And if you do have a will, maybe do you remember who your executors were? And are they still appropriate? You really should satisfy that for yourself, even if you've done your will. And you may need to update it, as we've said. And finally, keep in mind that you can use a professional executor service, and that will cost, it can cost quite a lot, frankly. It can cost over 4% of your entire estate. There's various services that do that. So again, weighing up the pros and cons of, do you have someone personally or not? And do you want some sort of organisation like that to do that? Is a question for you to answer. Okay, when should a will be updated? So really, there's quite a few scenarios, but let's just give you an idea. So typically, if you're onto it, you might have a will as soon as you get married that first time or whatever it might be. And often the start of a family will see an update of a will, adding children, etc. As I've mentioned, you've got an executor in place, but that executor may not be suitable. They may not live anywhere near. They may not be alive, and you may have a falling out with them. Who knows? But the executor's position may well prompt you to update your will. And similarly, as we all know, a lot of marriages end in divorce. That is definitely a prompt, and we'll focus on that in a moment to update your will. And also, a new marriage, a new family, other children, stepchildren, again, it's going to prompt you to reconsider your will. Okay, who else to consider in your will? So as I mentioned, if you've got pets, well, consider them in your will. And this is a broad idea of the various charities and causes you may wish to contribute to. That's a very popular thing these days, and on some platforms such as ours, it's very simple to find the charities that you support and include them as giving either a dollar figure or a percentage of your estate. We call it include a charity. So when a will becomes revoked, let's just focus in now on this marriage and divorce scenario. So a person's married, congrats, a will might be in place, and then they're divorced. What does all that mean? So in some jurisdictions, divorce will render the will invalid. The will is as if it doesn't exist for that person. But in others, because it varies from state to state, it will revoke your former spouse as the executor and any gifts left to them. So it kind of affects their involvement in the will, but it doesn't necessarily invalidate the wider will. So that's again a reason to get a new will, but need to bear that in mind. And similarly, if you go and get remarried, what happens to your wills? So a new marriage generally revokes a prior will. Again, still a need to update your wills, but that will be an impact on your wills. There is also a question I haven't illustrated here, but often the question has come up: does a will expire otherwise? Or, there's no, and the answer is there's no particular time limit on a will. Typically, it's an ongoing legal document and ongoing direction to the court. Okay, now this question has come up as well, and I particularly feel for the person who's asked it. The question was, what about separation if there hasn't been a divorce? And someone explained their circumstances to say they're no longer with their prior spouse and they live separately for many years now, but they never actually went and got a divorce because that was a costly process, which it is. Understandable, but this is like a red flashing light from our perspective, because this person without a valid will could see a scenario where their ex, their estranged spouse, gets potentially all of their assets unless they get a will in place to prevent that, because that person, in the eyes of the law, is still their spouse. And again, dying intestate, there's a formula that is how the estate is distributed, and that person would be viewed as their spouse and potentially could get all or at least a significant proportion of their estate. And keep this in mind if you are in the process of getting divorced and it hasn't all settled yet. Again, this is a big prompt to get your wills done ASAP. It would be quite a disaster for your ex to get assets that you have no intention for them to get. Okay, on the topic of final wishes. Now, this is really, it's like an added bonus of doing a will. It's not formally part of the actual will. So it's where you can let people know what you would like in certain scenarios and give them direction. And it can actually be helpful to prevent a future claim on your estate, as I'll mention. But the things that it can cover will be, for example, organ donations. Now, you'll probably nominate that elsewhere, but it will, again, give further support of what you actually want to do in terms of organ donation. Similarly, your plans around having a funeral, for example, or, excuse the graphic there, being cremated, if that's your call, then what is your actual wishes there? Now, what sort of music would you like played at any sort of memorial or whatever it might be? And how would you like people to remember you in whether it's drinks or whatever might be said about you? So it gives you a chance to give some direction on those sorts of topics. But as I mentioned before, it gives you a chance to actually explain yourself. If you've decided to give less to someone, what's the reason? Or more to someone else, what's the reason? There might be a very good reason that you feel they need more, for example. So by just explaining yourself, that is going to hopefully prevent a future claim, because the court would consider what your actual wishes were and potentially say, well, that was reasonable. That was what they actually wanted. So it's a chance to do that. Please keep that in mind. Now, why bother if your assets are modest? Let's look at some reasons. We've touched on some of these, and let's go a bit further. Essentially, if you've got kids, you probably want to assign guardians. Pets, again, who will look after them? You might want to support a charity, and you might have items of sentimental value, and you don't want people just to fight over them. Next, you want to prevent arguments just broadly. And again, the court costs, if you don't have a lot of assets, it makes the cost of involving yourself in the court even more important to avoid. And I shouldn't say involving yourself, I mean involving your loved ones in court proceedings that are avoidable. It's just really not worth it in a situation where your asset base isn't all that high. Again, great chance to outline your final wishes, so why not? And finally, while superannuation and life insurance are outside of the will, that's potentially your biggest asset. There could be hundreds of thousands of dollars tied up in super or in the insurances that you have either through super or in your own name, and it gives you a chance to address those and provide beneficiaries those funds in a clear and thoughtful manner. Okay, to lawyer or not to lawyer, let's get into that. So again, there are three main ways to get these wills done. Historically, it's the paper will kit that you might find, and I'd say it's roughly about $30 exercise to go and get the documents. On the other extreme is seeing a lawyer, and the pricing that we've found, and I actually used a lawyer to do my wills several years ago, and I spent many thousands of dollars to do that. And that's what we find, that the pricing would typically be starting at about $600 to could be $6,000 to get your wills done by a lawyer. And there's pros and cons with that, of course. And the platform that we would encourage, or the method that we really want you to be aware of as a potentially the sweet spot of these two extremes, would be the online will platform, such as will.com.au. And just broadly speaking, you'll find that wills on these sorts of platforms will range between about $100 to $250. And there are certain advantages with that, which I've touched on. In fact, we'll go into some of those now. So some other advantages of that sort of platform is, and I'll be speaking about wills in particular right now, is online chat, and whether it's phone or web chat, to actually ask your specific questions to people in the know. That's available for you during office hours, and obviously by email as well. But in terms of convenience, obviously you can do things whenever suits you, and you don't have to leave a couch. In fact, we might even overcome some of those lazy people sitting on the couch who will otherwise not do it to get it done, because you don't have to leave the home. But the big one, probably the one that people don't think of, is this review process and update process, and how not only efficient it is, but how cost effective that is. So if you can imagine a scenario where you need to redo your wills for some reason, and you need to go back to the lawyer, that's going to really create a lot of extra time and information upload and costs that you wouldn't get on a platform that already has 100% of your data, only needs a few tweaks, and then you can redo your will very quickly. So that's going to be a big advantage. And in our platform, that's the ability to do those sorts of changes comes at a very small cost. It's $1 a month to be able to do unlimited updates. So, and that's what people are choosing. So that is a key advantage of the online will platform. Now, question 2, and our final question, so get in there, but you've got to get the questions first. So, what percentage of UK wills are being written online? Is it A, B, C, or D? Someone's hopefully got the answer. And I'll just touch on that previous question, by the way. John Lennon did not die intestate. He wrote a will, I believe. Which one was it? Julian, his eldest son missed out or something like that, but he did have a will in place. Anyway, and for those of you, I'm sure you've answered this now. So 10% of wills are being done online in the UK. Okay, so we are about to wrap up. We'll go through some final next steps and those codes, and also how to ask us more questions. But it's a chance for Ryan now. Ryan's been looking at the various questions, and I haven't. If Ryan, if you want to join us with some of the questions, whether you take them yourself or I'll take them, whatever's appropriate.
Okay. Now? Yeah, so
Yep.
everybody hear me?
Yep.
I guess so. Okay, so I'll try to go through as many of them as quickly as possible. The first question was from Shirley: how do you prevent your will from being contested? I think Aaron covered some of those, but I'll give a particular scenario, and that's also linked to a question from David and Shirley around leaving out a family member out of your will. If you're going to leave, a family member like a son or daughter because you're estranged from them out of a will, the best thing to do is one of two things. One is to either leave them an amount in your will, not a nominal amount, but an amount nonetheless. It may be a lesser distribution than your other children, but at least leave them a distribution. Or alternatively, explain very carefully in your last wishes section why you're leaving them out. And that will influence the court in its determination if your will is challenged. Philip asked, what are the benefits or downsides of having an executor? Well, you have to have an executor. If you don't nominate an executor in your will, then your will is what's called partially intestate. And instead of applying for probate, a family relative will need to apply for letters of administration, which is when you die without a will, just to apply to be an executor. So it's really important that you do appoint an executor to administer your estate. Doris asked, can the beneficiary also be the executor? And I think we answered that. Yes, they can. And it says, if so, is there a danger of manipulation? Well, any executor of an estate has what's called a fiduciary duty to act in the best interest of the estate, which means they have a legal obligation to act in the best interest of the beneficiaries. So they can't just do something that is contrary to the instructions of the will maker. They have to follow the will maker's instructions, and if they don't, then they can be held potentially legally liable. Another question is, what if you can't find a will you made? Can you make another? And if so, does it negate the first? Yes, it does. So our will platform, as well as any will you get drafted, whether it's a will kit or whether you go to a lawyer, will have a term in it that essentially revokes your previous will and states that this new will supersedes the previous will. Jeff asked, can we have joint executors as distinct from backups? And can a child be an executor? So a child cannot be an executor. Some people name their children, non-adult children, as executor, which is fine as long as when you die, they're adults by that time. Otherwise, again, it's partially intestate. Whether or not, if you have joint executors, executors can be appointed to act jointly or to act severally, but you should still have a backup. The backup can be the survivor of the two if one of the joint executors dies, or you can simply have separate backups as well. Julie asks, are there any complications when one of my beneficiary children is living in the USA? Look, there's no, you can name anybody in Australia overseas as a beneficiary of your estate. Obviously, if you say, for example, leave your family home to your child and they're living overseas, well, it's a bit harder for them to take possession of the house and sell it. The practical difficulties is that there's no legal barriers to a child from overseas inheriting your asset. What about a child that is adopted? Mary asked. Some wills may make reference to natural born children, so you just have to be careful to look at what the definition of children is. Best to name your children, but generally speaking, adopted children are your legal children, but you should be very clear to name the specific children that you wish to leave assets to. I think another question, do all pages of the will have to be signed? Yes, every single page has to be signed. Doris asked, if one child to pass my wealth, does super need to be a binding will? So as Aaron explained earlier, superannuation is a non-estate asset and therefore it sits outside your will. So you need to go to your super fund, contact your super fund and fill out what's called a binding death nomination form. You can even find them online with some of the major super funds. And in the binding death nomination form, you actually nominate the individuals to receive the benefits or the cash from your superannuation. Most people usually have their beneficiaries in the will as the same people as in their binding death nomination. Some people have forgotten to do that when they died, to fill out a binding death nomination. So in that instance, if you've named your beneficiaries, the superannuation trustee will look at your will and use the discretion as to who to distribute your superannuation contributions to. It says, why can't a daughter-in-law contest a late mother's will? Well, look, there are categories of children that or relationships that can contest the will. Certainly, it is possible as a relative for a daughter-in-law to contest the will, because it's not only about the relationship, it's about that moral duty to provide for that person. So, for example, if that daughter-in-law is a dependent, that may be grounds for them to challenge. If no allocation in the will has been made for them, or minimal allocation has been made for them, then that's a ground. Whether they have a physical disability or mental disability that they need support, or other things like as they were before the will maker died, that daughter-in-law or other relative was actually a dependent of or lived with the deceased will maker. I have another few questions. If you don't have any family or close friends, who do you suggest as executors? Well, if you don't have anybody appropriate, you can appoint a professional executor. There are professional executor organisations, and will also can act as your professional executor. When you go through our platform, you can actually nominate us as your executor. Elizabeth asks, if you own assets in Australia and overseas, can or should you have two wills? Well, look, if your assets are in Commonwealth jurisdictions such as New Zealand or UK, then when your Australian will may suffice. You can get it sealed in those countries. It means you apply to the courts in the UK or New Zealand, and they'll reseal it, and you can then use that will to apply for probate. But if it's other countries, Philippines, China, Thailand, USA, there's one of two ways you can go. One is to do an international will, which our platform doesn't do just yet, but it's certainly a product we're looking into, or to do two separate wills. But you have to be very clear in each will that this particular will only covers your Australian assets, and this other will only covers, say, for example, your United States assets. Because if you don't do that, then the one that you do later may supersede the earlier one. Neil asked, do your witnesses have to read the will? No, they don't have to read the will. They should at least identify that you are the person signing the will, but they don't need to read the will. Doris asked, please explain a power of attorney. I'll just basically explain. The power of attorney is not part of a will. It's sometimes called a living will. Power of attorney is simply an instrument that allows you to appoint someone as your attorney to make financial decisions for you if you lose capacity while you're alive. So if you're dead, an enduring power of attorney is no longer valid. It only applies when you're alive if you're unable to make decisions for yourself. That's different to an enduring power of guardianship or a medical decision maker, which allows the medical decision maker or guardian to make healthcare decisions about, surgeries, where you live. That's called a medical decision maker or enduring power of guardianship. And a few more questions have come in. I'm just going to have a look. I haven't written them down.
What about joint wills, Ryan? Can you make a joint will?
It's legally possible to make a joint will, but you don't see many joint wills, and I would never advise a client to create a joint will, and the will platform doesn't allow you to make a joint will, simply because it's very prone to error and it's very inflexible. Because once you pass create a joint will, and one of the will makers dies, the surviving will maker's circumstances in the future may change. The property may change. The executors may want to be changed because they die, for example, and the beneficiaries may change. But you can't change your will. So it's a very inflexible will, very dangerous will. Under no circumstances would I ever recommend a joint will. Is my partner not technically contributed to home? Is he entitled to any share of my will? Well, like I said, it's about the, I think we explained that earlier, about the nature of the relationship, about moral duty to care for them, whether they've had adequate provision, about whether or not they made financial contributions is more of a family law issue rather than an estate issue. Aaron, do you see any other questions there for me?
No, I don't, but I think we've had a great flow of questions, and they'll keep coming, and we'll have a look through the chat. If we can reply to people in this platform, we'll try, but I'll also mention another way to keep asking the questions and getting answers from us. More than happy to do that. So thanks very much, Ryan. Okay, so what I'll do, actually, I did want to back up one brief point, actually. When we spoke about the various types of wills, I thought I should just mention a couple of key disadvantages which are just not obvious. So again, you can go and get the will kit, but these are very much prone to error because you can just leave off a section altogether, and that's going to just potentially lead the whole will to be invalid. That's a real concern. And also being able to use backups. There's not much flexibility and sophistication of any such document, no matter who drafts it. On the will platform on Willed, those things are dealt with by it being protected against those sorts of mistakes. You have to enter key things, and those things have to get populated into the final will, and again, having options for all these backup contingencies. And look, the disadvantages of using a lawyer in some respects are self-explanatory. So I really wanted just to highlight that in case people did think, you know what, I'll risk it and I'll just save $100 or whatever it might be. I really don't advise you to do that.
Aaron,
okay. Yes.
I've heard of instances with the paper will kits where this might be what you're saying, but just more specifically, where they've not filled out certain parts of the paper will kit, and then they're somehow magically being filled out once they've posted it or handed it on to. Is that something? Is that an urban myth, or is that something that has happened that you know about too?
Well, I'll answer that question. Yes, it has happened, and in fact, and I'll give a tip to your listeners. The Supreme Courts in each state in jurisdiction in which you apply for probate, you have to provide a copy of the will, and you have this. You know, I can imagine this very old man who's been there for 100 years in the probate office, getting a copy of the original will and really examining it closely. That's what they do. And they even look for if different pens have been used, if pages have been lifted out. They even look in the corner as if the staples have been removed. So that's one of the tips, is that staple it only once. And if you do happen to have to, for some reason, to photocopy it, for whatever reason, you take the staple out, put the holes exactly, staple it where the holes are exactly. Otherwise, that actually might get the will rejected. So the courts do look out for those type of things.
Thanks, Ryan.
Thank you. All right, we're about to wrap up now. Now, how to ask further questions? So the best way, beyond this platform, of course, is this webinar. The best way for I would suggest is simply to go to will.com.au, and you'll see this orange icon, Chat with Us Live. It will pop up, whether it's on your phone or a desktop or laptop, it won't matter. That will pop up with something like this. You can actually see Ryan's picture there, but you'll be able to chat with one of us, whether you do it now, potentially after hours, but it's that chat support is 9 to 6 p.m. during the week, but you can send an email and we'll respond that way. But chat is a really popular method, and I must say there's no demographic that doesn't use it. 60 plus, 50 plus, whatever it is, chat is just a very good way to interact, as you're seeing right now. So please do that, and we'll do our very best to answer your questions, and this is just part of the support you get through our platform. Okay, next steps, let's summarize it. So really have a think about these things. Think about who takes these roles and have the discussions. You can do that. You've probably done it to some degree, but now it's time to really solidify it in your mind. You can take notes. I'd encourage you literally go on to will.com.au to capture it all. It's free to enter all your data there if you like. You don't pay for anything till the very end, and it's a good way even just to organize your thoughts if you like. Capture it all in that platform. And now I'm about to give you the way to secure your discount. You want to do that. You'll probably want to write it down or email yourself or whatever it is. I'll give that to you now. So to secure the discount, this is it, 20YLC, 20YLC. And then you pop that in under will.com.au. Now, where you pop it in is actually at the very end. You'll enter it as a promo code, and you'll get 20% off at the checkout. So the price, by the way, is $159. That's the standard price. But if you pop that in the bottom right corner, you'll get 20% off your will. Now, it's fine to share this promo code. It's not top secret. We are happy for you to share it, but keep in mind, this offer does expire at the end of this month, October 31st, 2020. It gives you a good chance to get it done, probably enough time, and go ahead and get that done. Thank you so much for being in our audience. As I said there, sharing is caring. You'll get an email. You actually get a copy of this webinar. Again, share it, email it to other people, like it on Facebook, etc. Because really, this is also about taking care of your loved ones so they get well organized and they get willed themselves. Thank you so much to Your Life Choices as well for this wonderful opportunity, and have a great day.
Yeah, thank you, Aaron and Ryan. And thank you all for being a part of this webinar. It's been good fun, and we hope you've learnt a lot. And thanks for being a part of the Your Life Choices family.